The Positive Pause is a motivational-minded podcast covering topics women want to know about as they journey to and through menopause, focusing on subjects that impact women's health and healthy aging, including what it means to age healthfully. The Positive Pause features experts and influencers from a variety of industries and specialties. The information and opinions expressed on the Positive Pause are not intended to replace the services of trained professionals or to provide specific medical advice. To see the National Menopause Foundation's full medical disclaimer, please visit nationalmenopausefoundation.org.
Welcome to the Positive Pause. I'm Claire Gill, founder of the National Menopause Foundation. Joining me for this episode is Jack Tuckner and Catherine Crider, lawyers and women's rights workplace attorneys, all at the firm Tuckner, Sipser, Weinstock Sipser in New York. It is perhaps the only law firm in the nation concentrating its practice on workplace gender rights. Mr. Tuckner and Ms. Crider's practice is focused on helping working women combat sexual harassment, pregnancy discrimination, and other discrimination and illegal treatment faced by women, including illegal pay disparity, gender discrimination, maternity leave matters, unlawful retaliation, and wrongful termination. Jack has long fought for women's rights and against the unequal and wrongful treatment of women in the workplace. And Catherine also happens to be a doula, so she's very aware of what women's reproductive rights are needed. In doing so, both Jack and Catherine have gained a reputation for feminist activism and the pursuit of gender justice in pay for all women. Jack is a pioneer in fighting against the many forms of pregnancy discrimination, including the illegal actions taken by employers to try to force women to quit their jobs and the denial of workplace promotions and other benefits. Thank you so much for speaking with me today, Jack and Catherine.
Thank you
for having us, Claire. Pleasure to be here.
So let's start talking about your career and your practice and how you came to make gender workplace issues a real focus of your practice. So Jack, why don't you start?
Thank you, Claire. Well, quite a non-linear career that I've had. I actually dropped out of college. I was an actor for a while. I went back in order to finish college when my law school, which is the City University of New York Law School at Queens College, opened in 1987 because its commitment was to serve the interests of people's needs, human needs. It's on my diploma, Law in the Service of Human Needs. So it's a progressive lefty law school that sort of fights against the notion, which most people hate lawyers, and I don't blame them. The notion that lawyers make tons of money and they represent corporate interests and they're really not, and everybody knows this who's tried to find a lawyer, possibly with the exception of a personal injury case, because lawyers are mad expensive. Except for in the civil rights practice, we tend to not get paid directly by clients. But I digress. When I left this law school, I started as a public defender, which was right up my alley. I was working in the Bronx, if anybody knows that jurisdiction, during the crack years when our mayor was Mr. Giuliani, and there were many arrests for many people that were not guilty, crimes that were overcharged, and I really cut my teeth serving the underdog during those 10 years, trying cases as a public defender. And around the late 90s, I was at an event in Kona, Hawaii, and I was struggling now with what do I do with the rest of my life because I was reaching that burnout stage that many criminal lawyers do in public defense. And I sort of asked, I just was up on the top of a mountain, was asking, what's next for me? And it sort of struck me like an epiphany at that time that women, and I grew up, by the way, in a matriarchal household where I've always been sensitized to the notion of women's plight, the absurdity of it, the fact that my mother couldn't obtain her own credit card when I was a child without my father's reluctant co-signature. It was like all of this was just so maddening to me. And my mother, by the way, was sort of forced to stay at home back then.
Yeah.
Right? And couldn't have the career and really wasn't permitted by her family to attend college. It's all these injustices that, fortunately, when my two daughters were born, we were able to, and times had so changed, turn that all into this is sort of we're going to bring you up in this sort of gender neutral way. And there's not going to be, to the extent that we're able to do that, even in the culture that's still fairly sexist and patriarchal. But it struck me that women are the largest minority group in the country, and that really no one was advocating for things such as equal pay. I mean, they were few and far between lawyers who were looking at this and saying, what about pregnancy discrimination? Which is still a real thing, but it was nuts back then. And this is all pre-Me Too movement, sexual harassment issues. Yeah. So at that moment, I decided to commit my practice to empowering women and working for women's workplace rights. And I really never looked back, and it's been quite rewarding. And what I'm surprised about, because when you read at the beginning, we're possibly the only law firm in the country that concentrates on women's issues at work, that's probably not true now. But back in 1998, it was definitely true.
Yeah.
So that's the genesis, Claire.
Well, that's really important. And as you said, when you start to talk about some of those statistics about women not having the right to open a bank account or have a credit card or do any of these things without a male, her husband's or spouse or her father's signature, that was not that long ago. And I think we take for granted now so many of the things as women in the workplace that we feel we can and should be able to do, but really realizing that that's only come about in the last 30 to 40 years, and that there are still so many women who struggle because while it might be the law of the land, and we have people who, know that now and sort of are advocating for that, like you and Catherine, in a lot of areas, that's still not happening. And women don't know that they have the right to sort of ensure their workplace has the protections in place for them, whatever those might be. And obviously, as we're talking on this podcast, we're talking about women at midlife. And I think, again, it's sort of my generation, a little bit younger and a little bit older, who are sort of struck by now that we've hit midlife. Wait a minute, if I'm having these issues with my menopausal symptoms that are impacting how I work, and we know so much more about that now, it's really fascinating to find out that there's really nothing in place when it comes to workplace menopause specific. And we're all sort of trying to figure out what to do about that. So I'm just grateful that you guys are around to talk about this, and that you have some of that precedent on, again, the other types of women's rights that you've been advocating for over the last several decades. Catherine, I'm interested in how you got into law, and also how your role as a doula influences how you might practice law.
Great question, Claire. So I actually started as a teacher. That's my background. I was teaching in Boston schools for a little while, and I realized that I could do more for the classroom if I was changing policy. So I moved coast to the West Coast, and I started doing law school at night while teaching during the day, because I like that balance in my life.
You overachiever.
But in order to do that, I did have to switch to teaching a little younger. So I started doing preschoolers. And as their families started growing, I came to see how strong the needs really are for families that are growing and the supports that they actually needed. And that led me to become a doula. And while being a doula, it was actually, I started doing a lot of writing, and I came in contact with Jack. And that's really led me to feel passionate about the fact that it's not just young growing families that need these support. It's women of all ages. Particularly something I'm seeing a lot in my doula practice right now is that women are deciding to become parents later in life. We have the science, we have the culture that supports that a little bit more than previously it was. And so now people may be in perimenopause when they become pregnant.
That was me.
And in fact, with the help of IVF, sometimes you can even be in menopause and decide to expand your family. Yeah. So it's really important that the work that Jack's already been doing in the pregnancy world begin to extend later into people's lifetimes as they go through more of those changes. And so that's really what's led me into this passion as well.
It's fascinating that you have, again, those multiple kind of career pursuits. And you too, Jack, is how you got into it. But Catherine, one thing I just realized, people might not know what a doula is. So I actually didn't until my nanny, and I was one of those midlife moms. I was almost 42 when I had my daughter, and our nanny had left because she had gone to school to be a doula, and now she was joining a doula practice. So just very quickly, briefly explain to people what a doula is.
Great question again. So for people who aren't aware, it's an ancient Greek term, and it means like slave or helper or women's servant. And it comes from the idea that in older cultures, when people were birthing and things of that nature, other women were always the ones to support them and were always the ones around them. Modern culture today has extended doula. We now have death doulas. We now have sibling doulas. There's all different types of doulas. But the basic idea is it's someone who comes in with knowledge in an area who can emotionally and physically support you during a very important time in your life.
Yeah, it's like you said, it's such a normal practice in other cultures that women who are going through those transitions, major life transitions things, especially around birth, have that support network and that person with that knowledge to it. So yeah, it's really great. And by the way, just throwing it out there, there's actually organizations and associations for doulas. So if this is of interest to you, please check it out. Okay, now let's look back to our law discussion. But I really do think it's all really connected. And I love the idea of supporting women through all aspects of these transitions that they're going through. So like I was saying, we know that women at midlife make up a huge portion of our population and our workforce. And we do know that there's a negative impact on women's well-being, as well as potentially work performance sometimes because of these menopausal symptoms. And there's been a lot studied and talked about recently about, again, the cost that we face as a workplace when women are experiencing menopausal symptoms and might be needing time off for work or having issues. So I'm curious, Jack and Catherine, what should women consider when they're thinking about potentially asking for accommodations for symptoms that they're experiencing about menopause, which is a natural life stage, just the way motherhood is for those who choose motherhood. But when we're talking about menopause-related symptoms, and as we said, that's kind of not been discussed before, how should women start? What should they consider?
Well, here's the thing. There are protections, though, Claire. It's just that, right, nobody's talking about it, and there isn't a specific law. And when it comes to women's reproductive issues from menses through menopause, it's taboo. It's made to be icky in our culture. Nobody wants to talk about it, unlike if it were men that this were happening to. We are a regressive culture that we're the only nation in the developed world, in the industrialized world, that does not think it's important enough to pay women during maternity leave. The only nation. I mean, there's like three others, like Swaziland and Papua New Guinea. Literally, we are outliers at the bottom of the barrel. We don't care about women's issues. But it was the same for pregnancy. For the first 20 years that I was working in this realm representing women, people were like, what? There is no protection. There is nothing. If you need reasonable accommodations during your pregnancy, that's not on us. You're the one who chooses to get pregnant. It's not a disability like menopause. Pregnancy and menopause are not disabilities themselves, but the symptoms. So, for example, let me just go back a little bit with pregnancy. Used to be that employers would find all kinds of ways to say, you're not entitled to maternity leave. You're not entitled to flexibility during your pregnancy. But women were, and there was a way, because it's sex discrimination or disability discrimination, for example, postpartum, if you're not permitted to have a reasonable leave, even if you're not covered by the Family and Medical Leave Act. So now, 10 years ago, New York City enacted a Pregnant Workers Fairness Act that specifically addressed, yes, pregnancy itself is a protected status. And pregnant women, even if they're not disabled, the natural limitations of pregnancy that we know about, the need to use the restroom more frequently, orthopedic issues, fatigue issues, etc., are now to be accommodated, not only in New York, but last year we finally passed, after 20 years of effort by all of us stakeholders, the Pregnant Workers Fairness Act, which covers all women in the United States now who work for an employer with at least 15 employees. Finally, it's done. There's still much discrimination occurring,
Yeah.
but now we have a specific vehicle. Shifting to menopause, which is just another end, the bookend of the reproductive life cycle. There's currently no law, very little case law on the subject, except here's the thesis. This is what I've been talking about and what is still actually a fact, is that perimenopause and menopause-related symptoms often meet the standards under the Americans with Disabilities Act, because those symptoms can substantially affect major life activities. What are they? There's a whole laundry list of them, but they include sleeping and concentrating and walking and standing. And there's a whole, so many times insomnia, very prevalent symptom, brain fog, hot flashes, all of these symptoms from neurological to, all of these can affect major life activities. And what does that mean? You're entitled with your employer to an interactive process, a cooperative dialogue, a discussion about what you need to help you perform the essential functions of your job, right?
Mm-hmm.
With this temporary impairment, right? And that is a protected request. Also, besides major life activities, if your symptoms affect bodily functions, well, the endocrine system is a bodily function.
Mm-hmm.
And when hormones are in that transitional period, and that's where hot flashes and insomnia and many other symptoms are arising, that's also defined under the Americans with Disabilities Act Amendments Act of 2008. You're covered. Then we add to this the fact that most women in perimenopause and menopause, the average age is over 40.
Yeah.
And 40 is the age that we are all protected under the Age Discrimination in Employment Act in United States law. And finally, it's clearly a sex-based issue. In the main, we're talking about all cisgender women, right, are the ones who will, if they live long enough, will go through these end life stages, right? So when one is, instead of, which I've seen way too often, if your employer does not know that you're struggling with perimenopause or menopausal symptoms, your employer will likely look at what these symptoms are producing consequentially in terms of performance, and they will write you up or try to performance manage you out the door, because from their perspective, and if they don't know any better, they're just saying, hey, listen, you don't seem to have the get up and go, the pep you used to have. You're not performing at the level we've come to expect of you. Now you're on a performance improvement plan. And if you're on a performance improvement plan, it means that you're probably not going to survive that performance improvement plan. And also, many women, unfortunately, end up leaving the work voluntarily, self-exiling, right?
Yes.
Because of fear and depression and everything that's going along with this, and not feeling valued, possibly in the shank of their career.
Yeah.
So I understand that, first of all, it requires awareness, because a lot of women I speak with are not really sure what's going on.
Right.
And women also, unfortunately, get gaslighted when they go to even their primary and they say, these are my symptoms. And the primary, who's clueless, perhaps, says, well, maybe, here's a Xanax.
Yeah.
Have a sleeping aid. No one's addressing the root cause of it unless you consult a menopause-aware practitioner like those that you recommend on the Menopause Society site.
Yeah.
Right?
Yeah.
So once you have that physician or menopause practitioner, it doesn't need to be a physician, but some practitioner that is at least documenting that you're in this life stage and these are your symptoms, you're entitled to say to your employer, and this is a civil rights protected request, as a woman of a certain age going through these life stage adjustments that are natural, I am requesting X, Y, and Z, a brief absence.
Yeah.
It doesn't have to be that brief, but you're entitled to that.
Yeah.
A change of schedule, a change of clothing that you might be otherwise need to wear and it's too hot. Like 10 teachers I'm currently representing in New York, they're all in menopause, tenured teachers. The school recently removed the air conditioning units from their classrooms because they said, time's up on your accommodation, even in the hot months. We can't afford to give you these. And we don't have to, because they were relying on an old construction of the Rehabilitation Act of 1973. They're not even aware of the current trends, and they don't want to be, most of these heavily male-dominated, in this case, school district. Mm-hmm. So we're fighting. I'm predicting that the school district is going to cave, because otherwise I would litigate this case, and they're going to lose because it's not an undue hardship. That's what an employer has to say. If you're saying to your employer, I need this minor adjustment because I'm going through this stage that will help me help you, will help me to continue to crush it at work.
Yeah.
The employer has to argue an offer of proof that says, well, we really can't do that because it just cost us way too much money to do that. Well, you're not asking your employer to retrofit the entire office in Braille. You're simply asking for what are typically, like air conditioning unit, minor adjustments. And here's the clincher. If and when you have, and I know sometimes it takes a certain amount of courage to sort of raise this issue, because people fear, I'm going to raise this issue, I'm going to be targeted, it's embarrassing. Yeah, but what's more embarrassing is what happened to another client of mine. She was put on a performance improvement plan by her younger male manager, and it was all because of her perimenopausal symptoms. And she chose not to raise the issue, and she was ultimately managed out. She was terminated. And then it's too late to raise those issues for the employer if you didn't raise it at the time. So it's really important.
That's a really important distinction, Jack. And I think we need to think about us as again, sort of a consumer advocacy organization, an educational organization, helping women and employers know, here are those things that are, as you said, currently in place that actually apply. We may not need to do anything new. We may just need to add menopause into the descriptor of the policy at work, the way that we have for some of the other protected conditions and situations. And as you said, if they're not really causing undue hardship to make an accommodation, whether that be temperature or, like you said, maybe flexible hours or something like that, then that's really reasonable. But both the employer and the employee need to kind of be a little bit up on what's happening and how it can be addressed in the workplace. And I think that's going to take a lot of work from all of us over the next weeks and months, and hopefully no longer than that, but sort of getting people to that awareness level of, oh, hey, yeah, this is why this fits under these already in existent workplace protections. And here's how women should address it. And here's how managers should address it. Right. And we talked a little bit previously about how do we get there? And one of the things that you and Catherine had mentioned is that you were working on a white paper. Can you talk a little bit about that?
Well, we're working on a white paper just to explain the need for a Menopause Workplace Fairness Act modeled after the Pregnant Workers Fairness Act that was passed last June.
Well, that makes sense. Yeah.
And it makes complete logical, legally consistent sense based on the rationale undergirding the Pregnant Workers Fairness Act, because it's all part of the same reproductive life cycle. And the Pregnancy Discrimination Act, the Pregnant Workers Fairness Act talk about related medical conditions to reproduction. Those are protected.
Uh-huh.
I mean, they talk about it in terms of pregnancy and childbirth, but it's related medical conditions to reproduction. So, of course, it makes sense to just take it down what happens toward the end of the reproductive life cycle,
right,
which is affecting all women, not just the women who choose to get pregnant, right?
Right.
And again, it's only because the women of a certain age tend to be we don't, right? Women and men of comparable ages in our culture are not treated the same. When Hillary Clinton was running against George W. Bush, they were both 60. One was central casting, salt and pepper hair, prime, the guy you'd want to see as your president. The other one, Rush Limbaugh and his ilk, were making fun of growing older before our eyes. And it's the same reason why I've said this to juries, why when you cast Clint Eastwood and Sean Connery and whoever's more current now, these old men with women 30 years their junior in their leading lady roles, right? There's a disparity. So women who are often at the top of their careers in their 50s are still short shrifted, though, by their companies. And look, it's taken celebrities now to say, like, oh, I don't remember who's who, but, fanning herself on a talk show saying, oh, I'm having a hot flash. And it's like, ooh, look what she said. And why has there been such secrecy around it? So here's the thing, though, about more than the white paper. Catherine and I and another colleague, Karen Giblin, who wrote a proposal for a Menopause Workplace Fairness Act. And Karen presented this to Congress last month. There was a congressional hearing on women's midlife health and menopause. Number of speakers. Karen was one of them. She presented our paper. Suddenly, 2 congresswomen are interested. She's meeting with them. I'll be meeting with them soon. I believe, assuming the election goes in one particular direction, that this will occur sooner than later. The winds are at our back. And it does still require that this is what I saw happen before my eyes with pregnancy, that we, including women, stakeholders who are experiencing this, are willing to step up and say to their employers, this is what I need, this is what's going on, it's not shameful. And the reason that this is so important is that even if your employer does not go your way and they say, no, we don't have to do that, we're not going to accommodate you, the request itself is civil rights, is protected activity, so that if things have to go south at work, if the employer can't maintain her employment, that will put you in a much better negotiating position to command a severance package if the marriage can't be saved, so to speak. Right. So everything about it is protected and is sort of standing up and championing your own right to be treated fairly and not have to suffer degraded terms and conditions of employment because of something that's beyond your control and should be entitled to flexibility by law already.
It's such common sense, right, is what it seems like to me. And I think that's really a good way to sort of think through how do we approach this from both the employer perspective and from the employee perspective, and certainly women. And so you mentioned Karen. I was at that policy briefing with Karen Giblin. Karen, just for listeners who don't know, she actually founded Red Hot Mamas, which is another menopause nonprofit that she started in the 90s. Mm-hmm. She's been at this a long time and does some fantastic programs in hospitals around the country. So I highly recommend people check out Red Hot Mamas as well for the great work that they're doing. And as you said, there was really just amazing support when she brought it up that, look, this has just been done for pregnancy. It makes perfect sense to continue this. And so I'm really looking forward to that. And as you said, I've had several conversations with members of Congress who have picked up on this and are looking at this as, again, just a smart, strategic, common sense next step to how do we address this now that menopause and perimenopause have finally been given the attention they deserve as far as the impact that it has on women. And that, again, normal life cycle, terrific, wonderful things that we live long enough to experience this. There's just some, accommodations that might need to be made, particularly, as you said, Jack, when we're at the top of our careers, many women at this stage of life. And so we want to encourage more women to stay in the workforce and continue to be hugely productive, hugely successful. And some of that might just need a little boost from the legal side to ensure that happens, because we all know just because it's the right thing to do doesn't mean it actually happens. So we're going to be around to make sure that it does happen. So I have a question then about, is there anything that women should avoid potentially saying if they're experiencing things, or just anything as you've seen in your practice that maybe we should stay away from and approach a little bit differently?
I don't think, because I like to sort of start out with, I don't think women need to censor themselves when this is going on, because there's not a whole lot that you can say that would be problematic. I think one thing to consider that's always important is that we're talking temporary. If somebody was saying, I mean, that's always about that, a disability and an accommodation. And definitionally, it's temporary until issues are managed medically or hormonally. We're talking temporary. There's going to be post-menopause, or somewhere, and I read somewhere in something recently where a woman influencer in this area said something like, first it's horrible, then it's great. And we're just talking about, menopause, post-menopausal, like it's certainly going to, the adjustment will resolve, hopefully, at some point. In the meantime, you're asking for temporary. You can perform the essential functions of your position. You're not saying you could not do your job. And what's important to say, this is really vitally important, is that this is an intersectionally protected status, in that we're talking about sex, age, and disability. That's a powerful synergy. And so by mentioning, just by saying, assuming that someone is over 40, going through these symptoms as a woman in this environment, you're simply putting in writing, key, always key, even if you have conversations with HR or your boss, have those conversations, but then put it in writing. It doesn't need to be officious or you just want a paper trail. Yeah. Because, right, what the company is not allowed to do ever in response to those protected requests is treat the complaining employee worse, to subject her to backlash. And that backlash is legally known as retaliation, which would be illegal. This is about declaring for ourselves for something that's important. It's a sex plus discriminatory issue, in that it's woman plus another factor. And here it's two more factors. This is what makes it so powerful. The fact that right now, and which is always, to me, always blown my mind, that the world, inclusive some of women, will say, we don't need that. Or even the men who rule and who make these decisions largely would say, like the Republican Party itself now would still say, we don't need this, it costs too much money, it's an entitlement. No, it will save money. Yes, it will be more profit for companies that are all profits over people. Then look at the profits. Yes. You're going to make more money by retaining your most talented women and by making these adjustments.
That makes perfect sense. Sorry, Catherine, you want to add something?
Yeah, I was just going to throw in, I think it's important for people to remember this isn't like a decision you get to make by yourself. This is a conversation that you do have to have with your employer. There have been situations that have not gone well for people in court where they've made unilateral decisions and just changed their work environment by themselves without coming in with the proper medical documentation, without having these conversations. You can't just wake up one day and decide you're changing the uniform code. Right, you do need to go through the appropriate steps. So as much as we're really stressing today, you do have these rights. You do need to follow the proper order of procedure. Recognize your symptoms, go to your doctor, get it classified as perimenopause or menopause, take that paperwork to your boss, and then sit down and have a discussion before you start changing your work environment.
That's a really good point, Catherine. As I've said, not many of us are gutsy enough to do that, but you never know. But you're right. This is a two-way conversation. And as we said, there are things that we can do, but you have to follow the proper procedure, right? You can't just, like you said, take matters into your own hands. However, there will be situations. I mean, again, collectively, we are all working on this. And I do think that we're going to see great advancement in the coming months and years for making sure that women at all stages of life are respected and treated equally under the law within the workplace. But if that doesn't happen, what advice do you have for women who have, experienced these issues, maybe gotten pushback from their employers, or again, dismissed when they raised it? Obviously, I would say the one thing is that they could find firms like yours that are out there, but what other practical advice might you have for women to think about if they've faced it or are facing it right now before we've had a chance to codify everything and make Congress approve it?
Well, it's my position that it's already protected. Now, I understand. Listen, my own wife said, my spouse, when she was going through this and was still working, said, I'm not raising these issues. I don't like my boss. It's none of their business. It's not going to affect me. I have no intention of raising it. I don't want anyone to know. And I understand that. And one has to balance out. Can you grit your teeth and just deal with it, as many women do? And not every woman goes through symptoms that are extreme as others. So obviously this is an individualized choice. You have to decide, what's your position? Is it affecting performance that you understand or believe that your boss, your manager, your employer is noticing? You don't want to wait to be put on a performance improvement plan. You don't want to wait to get a bad evaluation, because then you're in reaction. It's still better than waiting until you're run out of town on a rail, but you would want to raise this issue because it's protective and you're showing optimal regard for yourself and your economic status and your family's income, because you're saying, I'm going through something which, forget about the terms, it's a disability. The symptoms are disabling. So if you broke your leg or had a heart attack or were going through a fibromyalgia flare-up, would you want to hide that if it was affecting your performance and you were sleeping 2 hours a night and your boss was saying, what's going on, sleepyhead?
Yeah.
And you knew that so it's always the employee's choice. So I wouldn't really spend too much energy on worrying about what not to say. But what not to say is that I can't work. Always with disabilities, it's like, I can't work right now. And they say, well, if you can't work at all, even with an accommodation, then it's not you can't work. So bye, we'll see you. It has to be clear that, of course, I could perform all of my job functions, perhaps remotely, especially these day and age. Perhaps right now, given the flare-ups I'm having that are documented by my practitioner, I need remote work for the next 6 weeks or 3 months.
Yeah.
And if you need an extension, you'll request it then, because I'm just telling you that despite the fear of big brother, corporations are reluctant when there's a written paper trail of protected asks, especially by women, to immediately throw cold water on it. They might do that. And listen, if they do that, if this was your question, Claire, if your company shoots it down and says, you could either do this job the way everybody does it, we don't want to hear about your mishigas, do it or don't do it. Well, then you have a choice. You could either say, okay, I'm going to go along to get along now. There's really no harm, no foul, really. And the request itself was protected in case there was going to be further backlash. Or at that point, you might want to consult with an employee rights lawyer in your area. And you have to determine, are you willing to stand up to them? Mm-hmm. And either to get the result that you want in terms of the accommodation, or if you'd say, I can't work for this company anymore and I won't want to if they're treating me this way, then maybe it is time to exit, except not by quitting,
right,
but by entering into a negotiation for severance because of the backlash. I would consider their declination of any accommodation to already be retaliatory backlash and illegal. I know there's no silver bullet for this, Claire. I'm afraid it's not as if
it's a very personal. It's a personal decision and personal choice.
It's very personal.
I think that the message for women is that there are options, and that only we can decide which of those options we want to pursue. And as you said, many women who have worked under these conditions for years and years. I think what's important, though, as now that we are at a little bit more of an awareness stage about menopause and midlife women's health, is that there is no prize for suffering and that there's no need to do it. So again, if you are fine and don't need any accommodation and you're not experiencing any of these issues that we've talked about, on today's episode, that's fine. That's terrific. And that's going to be quite a few people within the population, right? Many women say that to me, like, I didn't really experience any kind of really bad symptoms. And I always say, that's great. And I'm really pleased for that. But we just do have to know that many of our sisters, colleagues, friends, et cetera, have horrible experience during this particular stage. And so we just want to be respectful of that and let women know, if that happens to be you, you're not alone. And there are things that can be done to support you. So
not only aren't you alone, But I just wanted to say, last year I just started fooling around on TikTok, and I'm nobody's influencer. I got a few thousand followers, and I was doing it with my dog. It was kind of a goof. And I would just mostly do, though, pregnancy, because that's been my specialty. And, the usual, whatever. Some got thousands of views, some, hundreds. Again, nobody knows who I am on TikTok, and I would post infrequently. I did one on menopause, answering a question. My most viral one, 60,000 views, thousands of comments, hundreds of likes. And the reason that there's a hunger for it. Everyone was saying, oh my God, I never thought about it. My mother, me, my sister. This is so eye-opening. Now what do we do?
Right.
Well, I'm saying because of this groundswell, because of this is, again, you have what percentage, I forgot the statistics, but it's a huge percentage of our workforce are women from 40 to 60.
Mm-hmm.
So you have a deep need for this. And I do believe, especially if we all get involved, we can't do it alone. Nobody ever can. So it will take a certain groundswell. And you know what? It's not quite fully happening yet the way it did with pregnancy. Right. But I think that's why we're writing the white paper, to sort of raise awareness and to be able to share with lay people and lawyers alike to say, doesn't this make sense?
Yeah. Yeah. And in fact, just to be fair, I want to say we have heard at the National Menopause Foundation from many employers who are asking for advice on how they can make their workplaces more accommodating and stuff. And like you said, I think that groundswell is coming from both the employers and the employees. And I think it's going to be really interesting to see how it develops over the next couple of years. And again, because we're all working longer and we're living longer. So it's a natural progression that this would, if you think about it, need to be a topic that we talk about. Catherine, you were going to say something.
I think that going back to the original question, which was, what if they don't want to play ball with you? Something really important to do is look around for the accommodations your fellow coworkers are getting. Because a lot of times it's easier to have those conversations if you see accommodations for other things already happening at your office. Because those accommodations are already in place for your coworkers, it's easier for employers to implement them. So there's less costs associated for them. Those are the types of things they're really going to pick up on. So if you're already feeling uncomfortable about having to raise this issue, you're worried because you're getting a little pushback, an easy way to kind of ease into the process is by pointing out that some of your coworkers have similar accommodations to what would be helpful for you. That's also going to help you long-term if you do decide to go speak with a lawyer, because then you have fellow coworkers at the office that you can kind of compare yourself to as you have conversations with the lawyer.
Yeah, that's a great point. Great point.
It's a great point. And I just want to piggyback on that is not only just to say that my colleague had this accommodation, why not me? But they are your comparators in terms of discrimination issue. So when you're saying I need it for me, and here's this, for example, a male, you're the guy next door who's getting an accommodation for something. They go, well, yeah, he sprained his ankle, blah, 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 blah. Well, it doesn't matter. He's getting an accommodation for something that's temporary. You're providing it. You had an interactive process with him, and you're just declining to do it for me. That's the sex plus discrimination we're talking about. It's discriminatory.
Yeah.
So again, we're not looking to escalate this with our employer beyond the need to ratchet it up, like from DEFCON 5, so forth. You're not coming on to them as like, I'm demanding this. No. You're an at-will employee. You could be fired at any time. It's just the nature of our system. Unless you're lucky enough to have a contract or you're, in a strong union, which are few and far between, you can be terminated at any time. It's much less likely that you'll be terminated at any time if you've requested a reasonable accommodation, because that's protected activity. That's a civil rights request.
That makes sense. And I think this is one of those things where common sense will prevail, right? We're doing the right thing. And there's a shared goal. Both the employer and the employee really do want to be performing at their best. And so when you approach it in that way, right, this is what's good for the company, this is what's good for me, then I think we'll have a much better success at getting people what they need. We could talk about this forever, and I would love to continue this conversation too further down the road as we've had putting out there those successes that I expect that we will have and kind of getting some of these fairness acts, as you referenced, actually through Congress. And so we have a little bit more support at the national level and then doing the same at the state level. But thank you so much, Jack and Catherine, for sharing your expertise with us. We'll include additional information and resources about this topic and about your practice with the notes of this episode so our listeners can follow on and learn more. And I hope you've enjoyed this episode and learned something. I certainly have. So please subscribe to the Positive Podcast so you never miss an episode. And please share the information about this podcast with your friends and family. Thank you again to Jack Tuckner and Catherine Crider from the law firm of Tuckner, Sipser, Weinstock Sipser. And thank you for listening. We hope you'll turn in for another episode of The Positive Pause.
Thank you, Claire.
Thank you, Claire.